3, 2, 1, start. Bare perusal of the testimony of the complainant and the statements of accused persons under Section 313 CRPC would reveal that both the parties had inimical relationship. Stop. This fact has been mentioned in the first document prepared after the incident, that is the first information report. Stop. The FIR itself says that the rival parties had hostile relationship. Stop. Few months prior to the incident, election for assembly took place in which the complainant party was supporting an independent candidate while late Mr. Lal and his family were supporting candidate of political party. Stop. This created tension between the rival families. Stop. It is suggested that accused persons were in fact searching for right moment to attack on the deceased. Stop. This incident occurred almost 4 to 6 months prior to the main episode. Stop. Para. We have carefully examined the factual evidence of PW1 and PW2, and we believe that there is absolutely no reason to disbelieve or to discard their testimony. Stop. As far as question of lack independent witness is concerned, it is evident that in every case the independent witnesses are not available. Stop. It is also not necessary to produce them in every eventuality. Stop. When the witnesses of fact are not fully trustworthy, then alone courts can seek some corroboration. Stop. In the present case, evidence given by both PW1 and PW2 is highly natural and consistent with the normal human conduct. Stop. If the evidence produced by the prosecution is trustworthy and reliable, then this evidence cannot be rejected merely on the ground that independent witnesses, though available, were not produced. Stop. Criminal cases are decided on the basis of available evidence. Stop. If available evidence is trustworthy, then even the testimony of sole witness can be relied to convict the perpetrator of the crime. Stop. Para. Argument of the appellants that both the witnesses of facts are not reliable as both are partisan is not acceptable. Stop. Of course, both witnesses are partisan, but there is nothing on record to demonstrate that witnesses of facts are either lying or economical with truth. Stop. Fact of the matter is that it is much more difficult for partisan witnesses to spare real culprits of commission of grave crime like murder and to implicate falsely someone with whom they merely had some minor altercation 5 to 6 months prior to the incident on a very trivial matter during surcharged atmosphere of election. Stop. Ordinarily, people do take such things in their stride, and this observation finds support from a fact that neither party went to the police after this incident. Stop. In the instant case, FIR was lodged promptly. Stop. Initial medical examination was done at 3:30 p.m., meaning thereby that within 30 minutes of the said incident, both injured persons were present at PHC Kauripur, Allahabad. Stop. Incident occurred at 3 p.m. Stop. Medical examination started at 3:30 p.m. Stop. It can safely be presumed that injured persons and their supporters went to the Corihor PHC after spending some time at the place of occurrence and arranging a transport for the hospital. Stop. This indicates that prosecution witnesses did not get any time for fabrication, concoction, or false implication. Full stop.